Hey, welcome back to the law, Shanty. It's cold. Let me tell you that right now. And you can tell it's cold because our lips are all freezing up and we're stumbling over our words. It's cold, but it's nice and warm in the law, Shanty. Just so you know, I've got my law Shanty heater and my law Shanty slippers, and I'm cozy and warm. And I brought some guests in to talk to me today at the law Shanty. I know you guys like it when I do that because I get kind of boring every once in a while. So I brought some guests in today to talk about, well, we're going to go back and talk about vaccines again. And we're going to talk about, this time we're going to talk about incentivizing vaccines. So before we've talked about kind of the stick approach to vaccines. We're going to beat you with a stick if you don't take a vaccine by firing you if you refuse to do that. And we talked about the issues associated with that and the exceptions and the Americans with Disabilities Act and all that good stuff. Today, we're going to talk about incentive programs for vaccines, the CARED approach, and whether or not there's similar issues associated with doing that. And to do that today, I brought in two very, very bright associates from the firm. I brought in Ann. Ann Steen is the newest member of the Labor and Employment Practice Group. We do this thing at Warner where after a year, you have to declare a major. And Ann has decided she wants to be a labor and employment lawyer. So clearly we have not done a good enough job of scaring her away. And I'm kidding. We're thrilled to have Ann with us. It's fabulous to have Ann with us in the labor group. Say hi, Ann.
Hi, thanks for having me.
And I have with me Brianna Richardson's also here with us. I've been working with Brianna a little bit longer than with Ann, but Brianna is a member of the Employee Benefits Practice Group. Say hi, Brianna.
Hi, happy to be here.
Okay, here we go. Everybody ready?
Ready.
Okay, here we go. So let's start out on the labor and employment side because I know more about that. And when Brianna starts to talk, I'm going to glaze over because benefits just doesn't work for me. I'm not nearly smart enough to do that kind of work. So let's start on the labor and employment side, and let's talk about incentivizing vaccinations and an exception. So, Ann, if an employer provides a vaccine incentive program, do they need to provide an accommodation for that program under the ADA, for example? We'll start with that, like they would if they were requiring a vaccine. Is that part of the deal?
Yeah, so likely yes. Although it isn't entirely clear, a vaccine incentive program would likely be considered what's called a wellness program for purposes of the ADA regulations. And under those regulations, where an employer offers an incentive associated with a wellness program, they need to also offer a reasonable accommodation in order to enable employees who otherwise can't obtain the incentive due to a disability to have an alternative means to still get an incentive, the same incentive. So the short answer is yes. It is worth noting that in early January, the EEOC issued a proposed rule which may complicate this issue a bit going forward. So basically what the proposed rule does is change the standard for voluntariness for wellness programs. It may apply to certain vaccination programs, and it restricts the ability of employers in terms of what type of incentive they can offer associated with wellness programs or certain wellness programs. For example, in certain cases, employers can only offer what's called a de minimis incentive under the proposed rule. And they give the example of like a water bottle as something that might meet that standard. So in light of the change in administration since early January, it's not clear what the role or status of this rule will be going forward, but it's definitely something else to be aware of in that space.
Thank you. I'm going to tie that all together here in a minute for everybody. Just so you know, under the ADA, in order to ask the medical questions that you normally aren't allowed to ask of an employee, you can do that under a voluntary wellness program, but the voluntary wellness program has to actually be voluntary. And I think what the EEOC is saying here, and Ann will correct me if I'm wrong, is if you're offering a great big incentive, $1,000, it's not voluntary anymore because everybody kind of has to do it. But if you're offering a de minimis incentive, a water bottle, then it is voluntary. It's also ridiculous and nobody's going to go get a shot that didn't want a shot just because you're going to give them a water bottle. But that's where we are with the EEOC. But as Ann already pointed out, we do have a new administration. So this could change and we'll see what happens. That was a proposed rule, not a final rule. So let's get into one of my other favorite statutes in the world. which is HIPAA, because I hear this all the time. Hey, I've got an employee that won't tell me what's wrong with them, and they say they don't have to because HIPAA protects them. Now, 9 times out of 10, that employee is completely wrong, but that's the fun of the law. We get to, make lots of money telling you that they're wrong, and that's great. So, Bree, if I reward an employee for getting a vaccine, is that incentive program subject to HIPAA, and what does that mean?
So the answer is it depends, which doesn't seem that helpful, but vaccine incentive programs and whether or not HIPAA applies is really decided on a case-by-case basis. But before we can get into the case-by-case analysis, let me just take a step back and briefly talk about what HIPAA is and why we're worried about it. So HIPAA generally offers 2 main types of protection. The first is that it protects against discrimination based on a health factor. And then the second is it offers protections with security and privacy laws. In order for your plan to be subject to those protections, it has to be part of what's called a health plan, or it can be a health plan on its own. If your vaccine incentive program is not part of a health plan, it's likely not subject to HIPAA, although it will still be subject to the ADA. So this leads us to say, what is a health plan? This doesn't really make a lot of sense if we don't know what that is. So a health plan, the best way to describe it is probably by giving a few examples. So when we're looking at this, let's look at what the incentive is. Is the incentive something that can tie into a health plan? So say that I'm the employer. I offer you $100 if you go out and get a vaccine. Is that incentive tied to a health plan? Well, you're getting the vaccine on your own, and the $100 has really nothing to do with the health plan. So by the same token, I could probably also give you a gift card as an incentive or some extra PTO days. Now, on the other hand, say I tell you, if you go out and get the vaccine, I will give you $20 off on your health insurance premiums every month. Now this incentive is tied to our health plan. So this constitutes a health plan, and this is when we're subject to HIPAA. So when you're wondering if you're subject to HIPAA or not, look at what kind of incentive you are offering.
Okay, that makes sense. And by the way, I want you guys to all know what a great job we did training these 2 young lawyers, because one of them said it depends, and the other one said likely. And that's the second thing they teach in law school, is you always say it depends, because that's the way we go. All right, so let's go back to Ann. So the ADA requires this exception. Now we know on the we're going to require you side, the stick side, we also said that Title VII was involved in this thing. And if I had a sincerely held religious belief that I couldn't take a vaccine, you couldn't make me take it either. What about for an incentive program? Do I have to accommodate a sincerely held religious belief under Title VII if I'm providing an incentive?
So you're not going to like this answer because it's possible, even less clear than under the ADA. Existing case law it suggests that it may be difficult for an employee to bring what would be called a failure to accommodate claim in the context of a vaccine incentive program that they can't participate in due to a sincerely held religious belief. However, right now there's just very limited guidance in this area. So the safest practice is likely to provide these accommodations to employees who have sincerely held religious beliefs that prevent them from obtaining the vaccine, at least until we have a more definitive word from the EEOC on what this should look like.
Well, I guess if I'm giving out water bottles, that's not that big a deal. If you've got a sincerely held religious belief here, you can have a water bottle too. You can have a water bottle. If I'm giving out something a little more than that, that might be an issue that we'll have to look at and see if we get any additional guidance going forward. Okay, Bree. Let's say I don't want to do this myself, and I don't want to send my employees out to do this. Instead, I'm going to bring somebody in. Once these things become widely available, I'm going to contract with somebody to come into my facility, and I'm going to make it super easy for everybody to get a vaccine because I'm going to do it right here. Now, we do know from the guidance we got from the EEOC that under the ADA, as long as I'm completely separate from the administrator and I'm just bringing them in, I don't necessarily have an ADA privacy issue with that. I should be okay. What about, do I have a HIPAA privacy issue now that I brought somebody into my workplace to administer the vaccines? Would that implicate HIPAA?
Right. So the inquiry is going to be the same as what we did before. Is this a health plan? Is bringing someone in constituting a health plan? So one way to address it, we've talked about the incentive before, but let's look at the whole makeup of it. And when we're doing that, let's pay attention to the players and what they're doing. So for example, say I'm the employer. I have a local pharmacy come in and to administer vaccines, but my healthcare provider is the one who's paying for the vaccines. They're helping the employee schedule the appointments and they're keeping track of who gets the vaccine. I am completely separate from it. Under that example, there's a good argument that HIPAA would not apply because it doesn't present as a health plan. Like the ADA, you're very separate from it. So, but on the other hand, say, again, I'm the employer, I bring in a local pharmacy to administer the vaccine, but this time I'm paying for the vaccine. I'm helping my employees set up times to get the vaccines, and I'm keeping track of who gets it. Under that scenario, then I am likely subject to HIPAA laws because it is setting up like a health plan. You're getting the incentive and I'm giving you all the ways to meet the health plan. So like we talked about before, it's really important that you pay attention to everything that's going on. Who are the players? What are they doing? And what's the incentive?
Okay, well, that's all clear as mud. Thank you both very much for joining us. I'm kidding. You did a great job. Thank you both very much for joining us. We'll see you in a couple weeks. Bye.